Sarah Darren.
Mr. Speaker, thank you very much for the opportunity to rise in opposition to the Commerce Supermarket Adjudicator and Code of Conduct Amendment Bill 2015. So I think that I'm living in a little bit of a warped sense of reality, having listened to some of the arguments opposite, because I would simply say Commerce Commission. The Commerce Commission is our regulatory body that takes care of competition and looking at fair trading, and in my mind it's certainly working well, and the parent acts that govern it, the Commerce Act and the Fair Trading Act, are working well. So I don't believe that this bill is a strategic change for the better. In fact, I think this is just really messing around the edges and a little bit of jiggery-pokery. So as has been discussed before, the aim of this bill is to require a change to the Commerce Act and put in place a supermarket adjudicator to resolve disputes between supermarkets and suppliers. And again, my question is why? When we have the Commerce Commission, which is our primary competition regulatory agency. We've already got good legislation in place that's working well. The Commission was established in 1986 and it's an independent body. So its functions, its enforcement and all of its regulatory activities are independently undertaken. Yeah, the Minister of Commerce is doing a very good job in overseeing commerce and all that it entails. So, and the Commerce Commission's purpose is to achieve the best possible outcomes in competitive and regulated markets for the long-term benefit of New Zealanders, and I believe that it certainly is doing this. We do not need further red tape to complicate the issue. And that's something that I learnt. My colleague, the Honourable Jackie Dean, ran a series of workshops called Rules Reduction, and we had held one of those meetings in Invercargill. It was well attended, and one of the things that I learned is that people in general, especially in Southland and in New Zealand, instinctively know what is fair. And actually, people don't automatically revert to the worst case scenario in their dealings. We don't need to govern for that minority. So people in business don't like complicated or overly bureaucratic rules. We don't need an extra layer on top of legislation that is already working well. We don't need another adjudicator on top of an independent body which is doing its job well and completing its mandated tasks well. If you overcomplicate these rules, even good operators won't be able to comply with all of the red tape that's put in place. They won't have the time and they won't have the resources, and the only winners will be lawyers at the end of the day as they navigate through a complex set of rules, trying to trip up honest, hard-working businesses as they go about their fair trading. So, as my colleagues pointed out, last year the Commerce Commission investigated and found no evidence that a major supermarket company had breached the Commerce Act or the Fair Trading Act. And in coming to this decision, the Commerce Commission report did not indicate at any stage that it lacked the tools, the expertise or the resources needed to complete that investigation. And we have no plans as the government to compel supermarkets to enter into any industry code unless they want to do so voluntarily. We believe that people instinctively know what is fair. We believe that the existing legislation is working well and that the Commerce Commission is doing their job appropriately. There is therefore no need for this bill, and I therefore oppose it.